Hi, I'm Steve Worrall with Georgia Estate Plan Worrall Law. We are an estate planning and probate law firm serving Marietta, Cobb County, Georgia, and all of the surrounding areas. You know, a lot of people I talk to want to know how to avoid probate. And today we're going to talk about 4 ways to do that. If your assets pass to your heirs by way of a probate court, you know, a big chunk of the estate is going to get eaten up by attorney's fees, court costs, appraiser fees, and other expenses. Probate also delays the distribution of your assets to your loved ones. It generally takes a minimum of 6 months to complete and often takes much longer. If probate is contested by a dissatisfied heir, it can be years before the assets are distributed to your loved ones. Now, if you want to avoid probate, you need to convert probate assets to non-probate assets. Probate assets include real estate titled in the decedent's name, that's the person who's died, or as tenants in common rather than joint tenancy with rights of survivorship. Vehicles titled solely in the decedent's name, and business interests like a partnership or LLC or stock held in the decedent's name. Here are 4 ways you can avoid having your assets pass through probate. 1. Revocable living trust. This trust holds your property while you're alive and distributes it among your beneficiaries at your death. It's the most commonly used and versatile way to avoid probate, and probably the most foolproof way. As the creator of the trust, you're able to manage, change, and revoke your trust as much or as often as you want. During your lifetime, you can also use and control the assets that are placed in the trust. To avoid probate, an asset must be in or owned by the trust at the time of your death. Assets frequently placed in revocable living trusts include real estate, bank accounts, stock or brokerage accounts, and even motor vehicles. And your life insurance and retirement plan distributions can go there after you die. 2. Joint tenancy. This form of co-ownership often includes the rights of survivorship. So when one joint tenant dies, his or her share of the property passes to the other owner automatically without any need for probate. Joint tenancy is a common way to own real estate. Now in Georgia, you have to specify it that it's with rights of survivorship, but any type of property can be owned in joint tenancy, including vehicles and bank accounts. 3. Transfer on death deeds and beneficiary designated accounts. This kind of deed allows a homeowner to identify one or more beneficiaries who will receive the home on the owner's death. Unfortunately, we don't have these available to us in Georgia, but the same beneficiary designated approach can be used for life insurance proceeds and bank and brokerage accounts and your IRAs. It simply requires that you complete a form during your lifetime that's supplied by the financial institution that manages that asset. And lastly, 4, lifetime gifts. Assets given away while you're alive do not go through the probate process because you no longer own them when you die. Now notice this list does not include a will. Disposing of probatable assets in a will does not avoid probate, it guarantees it. So to recap, the 4 probate avoidance techniques are revocable living trust, joint tenancy, transfer on death or beneficiary accounts, and lifetime gifts. Depending on the mix of assets in your estate, you may want to use a combination of these techniques to avoid probate. We can help you choose the best approach for your situation. If you have questions or need assistance, please contact us at 770-425-6060. I'm Steve Worrall.